notice of general immigration law related options and not legal advice to any particular individual. After the webinar, if you would like to contact Praveen ji, his contact number is 847-995-1515. It's again 847-995-1515. And the firm name is www.bizlegalservices.com. www.bizlegalservices.com. bizlegalservices.com. So this is the contact number for the attorney. Thank you so much, Praveen ji, for taking some time to talk to us. So this is just a civic engagement type of webinar where we said it's not going to be a attorney-client relationship, but a general overview and general response to questions posted by our committee members or members of Chicago Andhra Association and beyond. So it's open for everyone, primarily for members of Chicago Andhra Association. With that, I would like to request the lawyer to introduce himself and also give us an overview of the current legal situation. Off to you, Praveen ji.
Hello, everyone. Thank you, Sundarvalli ji, for the introduction. And I'm really happy to be back again with you all. I think we got a gap after the COVID. We still did a few webinars, but I think we are again back to see, to help with immigration updates and any specific questions and options which are available for anyone. So with that, I think again, this March, we are back into very interesting time on the immigration updates that most of you might have already noticed and followed, that we got a very beneficial follow-up on the CISPA, which is a Child Status Protection Act policy. We got a new guidelines that how the children's age should be calculated for the purpose of crossing their green cards. So we'll also address those questions specifically if any of you have those situations, and most of the people have benefited with this new update, and we'll also try to discuss on those parts. And of course, as you all know, the lottery registration for the H1B has started on March 1st. It will last until March 17th. So employers would register people for the employees, the prospective employees for the lottery starting March 1st, and which has already started. Then the lottery would happen probably end of this month, which allows the employers to file for the H1B for the next 90 days. Presumably from April 1st until the next 90 days is a window for them to file for the H1Bs for people who are selected in the lottery. So with the recession and with the new updates and lots happening in the world, we'll see how this really helps people here. With that, maybe we can open the floor with any questions, then we can start answering.
Yeah. Thank you, Praveen ji. So just for the audience, we have sent out a questionnaire, and our team will post the link to that questionnaire once again on the Facebook Live page and YouTube page. If you have any questions, please post there. In the meantime, I'll start off with the questions we already received. So the very first question, Praveen ji, is with the mass layoffs, what are the options for H1 and H4 EAD?
Right. We've been getting a lot of calls on these options and questions, especially in the situation that most of these people are. When a person gets laid off being on H1B, then fortunately USCIS now allows a grace period of 60 days to transfer their H1B to another employer. As long as they get another eligible employment, they would be able to transfer. But at the same time, the critical thing here would be, it is either 60 days or the expiry of their current I-94, whichever is earlier. So it's not a standard that whoever has this situation has 60 days to file for the H1B transfer is not true. Then they need to make sure that the current I-94 is still valid for the at least next 60 days to avail this option. Otherwise, it's going to be an issue. The thing is, either it's I-94 or the 60 days, whichever is earlier. So, for example, someone's H1 is expiring in the next 3 weeks, assume, right, by March end. Then they got laid off today. So it's not that they have 60 days to transfer their H1 to employer B, but they have only 3 weeks until the end of March to transfer their H1 because it's I-94 or 60 days, whichever is earlier. If they have an I-94 which is currently valid for longer than 60 days, then they are good. They have more time. They have time until 60 days to transfer. But otherwise, you need to watch on your I-94 expiry. That's important.
So I think that was the follow-up question we had, like, is the 60-day rule still valid before they lose their status? And you mentioned that, yes, it is dependent on I-94. But wouldn't a person know that their I-94 is expiring in 3 weeks and they need to take some action?
Right. Usually they know, but again, not all the cases, right? So they might assume, in spite of their I-94 expiry, they think that, okay, we have a 60-day rule, so I'll wait for 60 days to complete this process, and the employers might not be aware. So it's in their interest that they need to communicate and let the employers know that it's an I-94 expiry, which is earlier than the 60 days, then they need to file the H1B transfer petition prior to the 60 days.
And same situation for H4 EAD also, right?
Yes.
If the H4 can the I-94 dates differ for H1 and H4?
Sometimes, yes, sometimes based on how they are placed, it's possible. Because I'll give you a typical scenario where that could happen. An employee who has probably their H1B approval until say 2024, right? Then they might have traveled to India, then they're coming back. Then their passport is expiring probably end of this year. Then their I-94 might be only till December of 2023, where the H1B until 24. Then later, the dependents, the H4 dependents might travel, and their I-94 truly reflects until 2024 because the husband's H4 or wife's H4, H1 is valid until 2024, right? So now you see that the I-94 is different for both of them. So it's possible.
So in that situation, they cannot bank off of the H4 and say, oh, all those things are not
Always,
feasible.
always it's the husbands or the spouses, the eligible
Primary
spouse.
persons.
The spouse's H1, which governs. If the H1 spouse does not maintain the status, then automatically H4 and H4 EAD will get affected.
Okay, so the next question is a very emotional topic to legal immigrants that India brings. Like, we follow the law, we come, and then the children are minors when they come, but then because of the long wait, children outgrow the parents' dependency status, and so after they are whatever age, I think you can tell the age, but after that age, now they are left on their own, like either F1 or H1 or something they have to do. And for them, America is the country that they have known all their life, and suddenly they face themselves in the situation where they suddenly become out of status. So can we talk about what is the law for people outgrowing their dependent status under the parents? And then the second follow-up question to that would be, what options do they have?
Very interesting, and we all have been following this since many years, and especially because we haven't got a chance to file for the final step of the green card process, which is I-485. And we have seen kids who came here, even in the community that we know, that they were actually going to middle school, then high school, then they're now ready to go to the colleges, and we still see that the parents did not get an opportunity to file their 485. And it was truly an emotional situation for most of us. And when we even attach ourselves, we know them personally, then definitely this becomes a major question in the community, or even legally whenever we address these situations at different forums, we try to bring a solution for this. So fortunately, the current administration has done what they could in their powers, I guess, at least as an interim measure, to read the CISPA guidelines, to update the guidelines, to make sure that we get the benefit of freezing the child's age based on the filing chart, not on the final action dates. So Most of the audience, they know that Department of State publishes two charts every month for the visa bulletin. One would be the final action date, and one is final application date of filing chart. So usually data filing chart, the intention is to give sufficient time in preparing and gathering the documentation before they are eligible to file for the green card. Then USCIS has a choice to follow either the data filing chart or the final action chart to accept the I-485 applications. Then when would the child's age be frozen for this benefit was a question. Then the previous guidelines said it is based on the final action chart because that's a true visa applicability date. But now the updated guidelines said that you can actually follow the date of filing chart, which is almost all the time earlier than the final action date. So that gives certain benefit for the people if they're aging out. And we have personally seen many of friends and many of the clients have actually qualified for that. And the kids who got a rejection on their I-485 applications because they aged out by the time the parents filed and by the time the final action dates become current, they could actually now benefit from this new update. So anyone who has that situation specifically has to look into it. If you had an I-485 denial because of the age issues, most probably you might qualify. You need to double check, contact your attorneys to learn about this. Then even sometimes sponsoring from India, US citizens sponsoring their siblings, it takes long time, 15 years, 16 years sometimes. Then their kids might have aged out and they might have benefit now if you really calculate all these things. So it's definitely something it could have done better than this, but at least this is something that we got in interim measure, I believe, which is a welcoming change.
So if the child stepped out of the parents' house and is on a F1 or H1 or any other type of visa, and now they are aware of this new provision that they can still go back under the parent to become a green card holder or whatever. Currently, if they are F1 or H1 or J1, any other visa, right? Can they also apply for this?
Yes, still doesn't matter. The thing is, since the update came recently and USCIS has allowed them to go ahead and file for the motion to reopen, or even if they have not filed this earlier, then we can examine the situation, circumstances, and make sure that they qualify under this rule.
What if the parents already got the green card? Is it still fine?
Yeah, it should be okay. The thing is, if there was a denial for the child for this reason, and USCIS allows us to actually file for a motion to reopen.
This is very good news for people listening in, because we thought once you have the green card, that's it. You lost it for good.
Yeah, the children did not qualify. But under this specific situation, if anyone qualifies and they fall into this situation, then definitely we can help them.
And is this only for, it's all throughout the 50 states, right? This provision?
Of course.
Okay, all right. So we will move on to the next question. If a H1 person applied for adjustment of status by way of green card processing and lost his job, can he stay beyond 60 days if he can't find the job because of adjustment of status?
Right. So the 60-day applies only to the non-immigrant visa, which is H1B, right? So if again the same thing, whatever we discussed initially, that either the I-94 expiry or the 60 days, whichever is earlier, they're eligible to do it. Then the green card, it again goes through its own set of policies and the rules that we need to make sure that they are complying with. For example, if someone filed for their I-140 and 485, and assuming the I-140 is already approved and the 485 is pending for more than 180 days, then if they know that they are going to get laid off or they have a notice period, then that is the time that they can actually look for another employer and move to another employer, and that is allowed under I-485 as an AC-21 portability provision, right? So they can move to employer A to employer B as long as it's a similar employment, and that actually follows the guidelines that what I-485 allows. But the 60-day rule again is based on the H1B. If they are on a H1B, then obviously they can move to a different employer prior to the expiry of the I-94 or 60 days. whichever is earlier.
So are you saying that this 60 days only for H1 adjustment of status, when once they reach that stage, it's considered like a free green card or something, so they follow the green card rules?
Right. So a person can have two statuses here in this situation simultaneously. A person is on a non-immigrant status, maintaining his H1, but the same employer might have filed for his I-140 and 485, which is pending, right? So then he can take benefit of moving from employer A to employer B based on the H1B, but still also file the AC21 I-485J is what a form that we file at this point to inform USCIS that they are moving from employer A to employer B, and employer B is still supporting their green card, employment-based green card. So,
and what if they don't get a job? What happens after?
Yeah, it does not apply. Then they will be out of status. Otherwise, they are supposed to be leaving the country.
So even if they're on adjustment of status, you have to have an active job sponsored by anybody, any employer.
Absolutely. It's an employment-based application. So you need to have employment-based support for you to continue the I-485 application.
Thank you, Praveen ji. So the next question is again a very emotional question. If a person is here in the sense in USA on a green card and lost his brother and sister-in-law, can he adopt the kids in India and bring them here as dependents as he is the only surviving adult in the family? What is the process?
Possible. Again, few ways of doing this, but what we always recommend or an easy way, a predictable way of doing this would be to adopt the child as long as they are below 16 years. Then if they have two siblings, two children, then if the older one is even above 16, still as long as you're adopting a child who is less than 16, you can still adopt the older kid also. As long as you're at least adopting one kid who is
minor.
Yeah, minor, 16 years or less. Then the requirement says that they have to physically be taking care of those children or having the physical presence with them for at least 2 years prior to the entire process. So they can file for the I-130 application if the person or the family who's US citizens adopting these children, then they can file for what is called Form I-130. But again, they need to complete the 2 years mandatory requirement to physically stay with the children. Then they can process it, and probably it might take few years for them to get to the stage, but still it's possible.
So until then, the children remain in India and the sponsor remains here, and they just have to find alternate.
Yeah, they need to have a physical custody. That's a requirement. So what that means is they need to accrue the 2 years period living and staying with the kid.
Oh, so they need to move back to India to stay with them to bring them back.
Right.
Is it if both are like citizens, right? So if one person goes, or if both are green card holders, if the wife goes, is that enough, or do you need
the US citizens that we are discussing, the I-130 that we are saying? But again, various ways. See, as you mentioned, then one parent staying, then another parent traveling. These are all possible as long as we can show that physical custody of the child. It's not that.
So that brings me to a good point. So this is applicable only if the person is a citizen, not if they're a green card holder.
Right. To primarily for a US citizen to start with, yes.
So what option does this green card holder have then?
Right. They can still adopt. They can adopt and go through this process. There is still a way to do this. But again, when are they eligible to get the citizenship? I would even just look into that, just see which is advantageous for them.
So any advice, like do they adopt in India or here?
Usually the adoption process happens in India, that they need to apply through the central adoption agency in India. Then they would go through the process and get the documentation. Yeah, it happens in India, to just answer.
Yeah, I feel sad for that person who asked this question, but yeah.
Right. Again, there is a way.
2 years.
Yeah, there is a way
2 years.
Yeah.
And they're minor children, and first of all, they're dealing with the loss of losing parents, and
there is a way to do it. Again, if they are green card holders, still they can file for the I-130. They're eligible to adopt. That's not an issue. But still, we need to figure out what is their situation, then where the kids are, where the parents are, where the adopted parents are, and how are they going to fulfill this requirement for physical custody. If they are green card holders, again, they have an issue of staying outside the country for more than 6 months, right?
Oh, yeah. No, that's another problem.
So that's the reason I say that probably going with the US citizens is what a scenario that we can discuss. But again, for green card holders, we need to make sure that they have more specific details so that we can advise them and see that this can happen.
So for people who joined recently, we are in this is Chicago Andhra Association in conversation with attorney Praveen C. Medikundam. Again, we read a disclosure at the beginning of this call saying that you have to, this does not qualify as a client attorney privilege and things like that. If you need to contact the attorney, his number is 847-995-1515, 847-995-1515. And his business is www.bizlegalservices.com, bizlegalservices.com. Just FYI, before I go back to my questions. So the next question, this is typical of our parents type of generation question. 71-year-old mother does not have a birth certificate and it's not feasible to get one. What are the options to file a green card?
Right. So usually we recommend them to file for what is called a non-availability certificate. They have to get this certificate from India. And just so that we all know that registration of birth and death is not mandatory in India. So some people might not have a birth certificate based on the procedures at that time or whatever the choices that they made. So they can always go back to the birth registry and ask for the birth certificate, or if they have not registered, they will look into that register and then they give what is called a non-availability certificate. It's a letter which explains that they don't have a birth registration. That's all. So as long as they have a non-availability certificate, then based on that, they can get affidavits from the people who are alive at the time of their birth, their siblings or elders, whoever are alive at this point, can give an affidavit saying that they know that this is their date of birth, along with the non-availability certificate. And we also try to document it with any prior documents or evidences, such as their government records, hospital records, or anything. So altogether, that's the presentation that you can actually do to the USCIS, that this is their birth information.
So my next question actually falls into that. If parents don't have marriage certificate, how do I apply for green card? Is that the same again, or?
Yeah, pretty much. It's a similar procedure. Again, I don't think they get a non-availability certificate for a marriage certificate. Still, that is possible. They can get it. Then along with, they have to get the affidavits for that.
So 20 years down the lane, if the child wants to bring the parent, and can they just go to the marriage bureau in India and say, give me a marriage certificate? Is that allowed? That's the first question. If one of the parents died, can the lady or guy go back to the marriage bureau and say, I'm transferring, can you give me a marriage certificate? Do they give that in India? I know I'm asking Indian law questions.
Right. It's different in each state. It's different in each procedure. But for the marriage certificate, it should not be difficult. Again, non-availability might not be required for a marriage certificate as long as you can show other evidences. Because this question primarily comes because a US citizen is sponsoring their parents, right? Either a single mother, maybe in this case. So then he might have already claimed that she's the parent or she's a mother in his documentation when he filed for the green card to start with. Then there are documents probably he or she already submitted. Then those are the things that you need to look into, then making sure that you are consistent in what you are providing here. So marriage certificate, again, might not be relevant in most of the situations. But wherever it is relevant, there is a way to document it with other documents.
Is it mandatory to have a marriage certificate for parents?
I don't think so.
As long as the sponsor shows the person as a mother or father in his own passport, he should be fine, right?
And not just the passport, because passport again is not a conclusive evidence, right? So any other documentation in addition to that, affidavits, those things would really help. And of course, the birth certificate would show, the birth certificate of the sponsor would show that the parent's name, right? So that would be more beneficial evidence.
Okay. So moving on, this is for people who already settled in USA and have US citizen as kids and stuff, and these are marriages type of question. Is there a risk in a US citizen marrying an Indian citizen who's already here on a J1 visa or H1 or F1 or whatever type of visa?
Right. Again, each visa category has a different treatment. J1 visa has a restriction to adjust their status in the US. So J1 has a mandatory requirement that they're supposed to go back to their home country after completion of their program. So then if someone is getting married to a US citizen being on a J1 in the US, have the same restriction. They cannot adjust their status. They cannot file for their green card right away. Unless they have a waiver from the USCIS and they get a no objection from the home country saying that their service is no longer required. So getting married is not a problem. They can always get married, that is valid. But for them to get the green card, definitely they have to go outside the country, stay, serve for 2 years, and then come back. Unless
also there's a two-year period.
2 years, 3 years, different J1 programs we have. So yeah.
And is it easy or hard to get all those waivers and stuff?
Right, getting a waiver is again a case by case basis, very difficult unless the particular government says that there is no objection from their end, and based on that we always file a waiver here in the US with the USCIS, and the USCIS would consider giving a waiver. And then once they get a waiver, they would be able to transfer to any other non-immigrant category, including H1 or F1 or whatever they wanted to do, including getting married to a US citizen or a green card holder and filing for the green card.
So if a J1 finishes the training here and then gets a job, can they apply for H1 or they have to go back?
They have to go back because the primary condition of J1 is for them to go back to their home country and serve. The program is designed that way, and they have the restrictions already mentioned on their visa.
Okay, and does J1 also have all these extensions like H1?
Right, the J1 can be extended as long as the program has those flexibilities, and the sponsor would do the documentation. Yes, it's possible to extend the J1.
And what about H1 and F1? That should not be a problem, right?
That should not be a problem. Yes, a person on a H1 can always get married and file for their green card in the US. Then F1, yes, still possible with certain restrictions that the intention of them to come to the US should be proved that they did not come to the US to get married and immigrate, even though they are using F1, because F1 is a specific purpose that they came here to complete their education. But it so happens that they get married to a US citizen, still they can file for their green card, but the primary motive should be to complete their education.
So the easiest bet is a H1.
H1, even F1, any other category other than J1.
Okay. Okay, so we'll move on to the next set of questions. Yeah. If we run out of OPT grace period before we get picked in a H1 lottery, what options do I have to stay here?
Right, tricky situation. Many students face this these days, and appropriate question at the time that we are filing for the H1B lotteries. And that's a good possibility for many people that they might not be picked, right, based on the numbers and the situation that we are in. So this is a good question for them to get prepared and be ready to trigger any options that they have. The first option that I see, people extend their F1 programs, maybe if they have interest in continuing their education, if they have to pick up a second master's or any specialization that which is useful for their career, and they can always pursue that. And maybe they can always pursue an higher education other than bachelor's or master's. Maybe they can go to their PhD if they have interest in pursuing that. I have seen many students opting that because that's the time that they can pursue their interest in education, right? If they have that kind of goals, that they can always achieve that. Then Other than that, maybe even going out to the PhD, they get the work permit now. These days, you have seen that there are many programs which allow CPTs. So the CPT might also help the curriculum practical training. So that is another option. Then again, more specifically, if someone in a situation where by after April 1st of this year, I'm just trying to construct a scenario so that we can really help some of these individuals into this situation. So assuming the OPT expires by April 15th, right? Then this is their STEM OPT, which expires. They don't have an extension on OPT. So an employer files for their H1 on, say, March 15th, and they get selected, and they have only 15 days to file for their H1, because prior to the expiry of their OPT, if the employer files for their H1, even though they have 90 days, then prior to the April 15th expiry of their OPT extension period, the last date of their OPT expiry date, they would be allowed to stay in the country, but they cannot work, but their employment can start from October 1st. I'm not sure
Okay.
if it's clear. I can again explain.
Yeah.
So,
That you
so an example is assuming someone's current OPT expires on April 15th or say May 15th, then this is the last chance for them to get the H1B selection, and they don't have a chance to extend it, right? And they get selected, as long as the employer files it prior to the date, they are allowed to stay back in the country to start their employment from October 1st. They are not, but they are not allowed to continue working after April 15th. At least that's a
so
chance.
how do they sustain themselves if they
Right.
the students obviously
Have
they
to.
not have heavy bank balance,
If they have savings only, they cannot work.
but can they go to India and come back in October? Until then, maybe just use a vacation or something like that.
Yes, yes. They can actually go back to India. They can go for the H1B stamping and come back.
Okay.
If that is, yeah, if that is possible, yes.
So on the marriage question, this OPT guys, is it easier if those people get married to citizens, or for them also do they have restriction?
No, they can.
OPT, there's no only J1 has that restriction. Okay. Wife is traveling on a H4, but I lost my job on H1, trying for a new job. Will she face issues? A caller is asking this question.
So, sorry, repeat your question.
Wife is traveling on a H4. She's coming from India on a H4, but I lost my job I'm on a H1 and I lost my job, and I'm trying to find a new job. Is she going to face issues?
Yeah. See, if he is in the period of the transition, 60 days or prior to the expiry of his I-94, that he's allowed to file for the H1, right? Assuming that he is into that grace period, then the same grace period applies to the wife. And usually we trigger this grace period if the wife is here in the US, but if she's traveling, then rather I would advise her not to travel. But that's a gray area where we can always argue that the grace period still applies even if she is actually coming through the port. But the best scenario would be if she's already here in the US, then she would be allowed to stay along with the husband when he is into this period of grace, the 60 days or the expiry prior to the expiry of the I-94. But if she's traveling right at the time, still she's eligible. That I would always argue that still she's eligible, but the recommendation would be to have her stay and have him file for the H1. Then of course she's eligible to travel because she has a visa, right?
So this is my follow-up to this person's question. Do the border security people get notice immediately when somebody is fired or something? Does it show up in the database?
Right. So
how do they know that this person's lost the H1?
So let's actually get the question, the format right. The thing is, it's not about they knowing or not knowing. It's not relevant for the discussion. But what is the right thing to do, right?
Okay.
So what is your legal status? So again, they knowing, not knowing is all an administrative process, right? So sometimes they might not know. It doesn't mean that you are doing it right.
Yeah. So we just have to be careful.
Right. So the right format of the question is to see whether this is right or wrong, right? Is this allowed?
Okay.
Yes, I assume it is allowed. I presume I support that argument that they should be allowed to enter the country while the spouse, the H1 spouse, is into that grace period, but difficult to defend at the port of entry to explain this. If at all they raise this question saying that, hey, is your husband currently working? Is this H1 still valid? Then obviously you need to explain that no, he lost the job and he's into this period of grace. Then he has 60 days to find a new job. Then he's allowed to stay in the country. Then the question is whether she's allowed to enter the US based on that situation. Then what is the guarantee that these people are going back if they don't find a job after 60
Yeah.
days? What is the validity of the I-94 that they give at that port of entry, right?
Right.
So rather don't face the situation, stay back, then have him file for the H1B. Then the minute they file for the H1B transfer, then she's eligible to transfer. Then they can
So,
do it in premium process, get it approved, then that would be easy. Yeah.
so this is a question from a senior citizen. I am a citizen. I retired and went to India. I get my SSN, Medicare, etc. Do I have to still file taxes if I live in India all year long and come here for a month or two?
Right. More tax related question. So maybe any tax expert, CPA should be able to answer that question. But my take that as a US citizen, they are required to file their taxes here in the US in any case, right? So whether they get income anywhere, it doesn't matter. They have to still file for their taxes here. Maybe
Okay.
that answers their question and their position, how they need to look into. And at least this gives them the guidelines to ask a relevant question to their CP.
Right. So I did notice some more questions. I will get to those. Just FYI, I'm going to finish the list on my thing and then I'll get to those. Just FYI. So the next question I have is: can I add dependents, wife and daughter, who are currently living in India for green card processing?
Right. Interesting. The thing is, yes, they can. But again, the filing for the I-485, which is adjustment of status, is possible only if they're physically present in the US. See, once they get an I-140 approval, the priority dates are current, they will be filing for their green card, which is an I-485 application if they're in the US, right? And we can file for their I-485 only if they're physically present here. If they're not, then we will follow a different procedure called consular processing for them. So that way they can appear in the consulate in India and they get their green cards.
Okay. So this is a parallel spin-off question. I've heard of cases like one of my colleague, his wife, they messed up and the green card was denied. That was one process. There was another person, a friend of mine, whose mom couldn't speak English and so lost the citizenship. She could not. She's a green card holder. She could not get. So in cases like this, where a spouse has a green card, but due to some reason the wife did not get, or the father is a citizen, mother could not get the citizenship because of English or whatever, can they refile, and what are the options for people like that?
Right, they can always refile. They can always answer those questions why they did not get the green card, right? So there might be a reason why she did not get a green card. Probably if she's not even eligible to get a green card, maybe there is a period of unauthorized stay in the US. If someone's staying here unauthorized for more than 180 days, they're not eligible to file for their green card.
Oh,
Maybe
okay.
situation that way. They are employed here without authorization. So that might be a reason. So we need to overcome those things, try to satisfy the requirements and fight on that if there is a way.
It depends on the situation as to what caused them to refuse it.
Perfect.
Okay.
Right.
Okay. The next question is: can I add dependent son for green card processing? And this son is on F1 visa, and person tells which university. But obviously he's asking, can I add a dependent son for green card processing if the son is on F1 visa?
Yes. Yes. It doesn't matter the current status, the current immigration status in the US. As long as he's eligible as a family member, then the father or the mother or the parents can always file for the child.
Okay. So just a comment to the audience. I do know you've posted some questions and I did get some chats and all. I will pick those up. Please be patient. We'll just go through the questions in the order that we received. I will definitely answer, ask all those questions that you've asked to the lawyer. Thank you so much. The next question is, are there any plans to reduce the required time gap between one getting a green card and applying for citizenship? Currently, it is 4.5 years or 5 years.
Right. I don't think, to the best of my knowledge, there is any proposal which they can change. But you know that a person getting a green card through marriage, if they got married to a US citizen, they're eligible to file for the citizenship after completion of 3 years. Then if this is an employment based or any other category, they have to wait for 5 years. But at least they can file for this application 90 days prior to the completion of 5 years. It's not 4.5 years. It's 5 years. The eligibility is 5 years, but 90 days prior to the completion of 5 years, they're eligible to apply for that.
I know the same person had asked more questions, but I'll come to it in the order. I'm going in the order. The next question is, I have my PERM and I-140 approved based on my Chicago office address. I am now working full-time remote and moved to Dallas area. Do I need to redo my PERM based on my current remote position and new location in Dallas area? What are the implications if we do not refile PERM? Thank you in advance. Should I read it? It was a lot, mouthful.
Yeah, no, straightforward question. This is a question more for the employer also who sponsored his green card. Then, yeah, obviously he's a beneficiary. He should be concerned about the situation. So the way that green card, the employment-based green card works is that an employer would test the market, the labor market in the area, in the geography where the employer has the employment for, right? If, for example, the employer is in Chicago, then he would always test the labor market here, file for the labor certification, advertises for either eligible US workers to apply for the job and then go through the PERM process. Then obviously for him, they might have done that labor certification process in the geography where the employer had that employment opportunity earlier. But again, change in the situations that now he is working in a different state. So obviously that needs testing of the labor market in that particular geography. Unless he still have that employment available for his personal reasons that he's working remotely, but the employer has this job available in his headquarters all the time, then he should be fine. So it all depends also on the employer, how he would answer this question, right? Where is the employment? Then employment, if it exists in Chicago, then his green card process is intact, even though he's working remotely from wherever it is. But the word that he said that permanently he's working from Dallas or somewhere in Texas, right? So what does that mean? That he is permanently assuming that he's going to stay there because he bought a home and he's staying there. But the employer might think otherwise, that he should be able to come back and work for him in Chicago, right? So if that is the situation, then as long as the employer believes that he's supposed to come back and he in fact truly comes back and tries to take this employment, then he's fine to continue on the same thing. But other than that, if the employer believes the same thing, that, hey, we don't have a job here, then the job exists in Texas for me, then obviously it has to go through the labor certification.
So this is my follow-up to this person's question. I've seen cases where those inspectors go and check to see if the person lives at a given address. Is that true? And does it apply for this person?
Yes, true. Always USCIS has that ability to go and check, to inspect the employer and to make sure that whatever you claimed in the application is correct, right? So,
but with COVID and now everyone working remote, is it not okay that the person moves wherever he wants to work?
That's exactly, he can. But as I said, the procedure is the position, the permanent position existed in the geography where they tested the labor market, right?
Okay.
So we need to correct that. Yeah, based on that. So otherwise there is no restriction. You can work from anywhere. But if you want to keep your green card, if you want to follow the procedures, then you need to answer these questions. Where is the position? If the position still exists here, then obviously whatever they did is right, and the intention is also for them to come back here and work permanently. Then if the position permanently has moved out of this region, then the labor market has to be tested there and file for the labor certification again. So that is also one benefit that USCIS allows to recapture the priority there. So he's not going back in the queue, right? So he still gets the same eligibility and all, but there's a procedure because it's more geography oriented.
Yeah, so it's a good segue for me to read your disclosure one more time, because we're talking deep into this law stuff now. This is Chicago Andhra Association in conversation with Praveen Medikundam, lawyer. Participating in this webinar does not, please note that point, does not constitute to attorney-client relationship. Using attorney Praveen or his firm's services requires the application of professional expertise and judgment on case-by-case basis, for which you should schedule a consultation and seek advice and services as required. This webinar is an effort to bring notice of general immigration law-related options and not a legal advice to any particular individual. Again, if you want to contact the lawyer, his number is 847-995-1515, and his website is www.bizlegalservices.com, bizlegalservices.com. So back to our questions again. Yeah, so the next question is from this person. Again, same scenario. Hi, I would like to know, when can we expect December 2014 to become current in EB2 category? And he has follow-up questions. I can read off everything and then you can answer, or we can do one at a time.
Yeah, we can read.
Okay, so the first question is, he wants to know when December 2014 is going to become current for EB2 category. His second question is, another question is related to birth certificates. Is it okay to provide birth certificate with minor name changes, or can we file an affidavit if the birth certificate is missing during I-485 processing? Please advise. Thanks.
Right. So December 2014 EB2 coming back onto the visa chart for filing or final action is something very difficult to predict at this time, because there's a lot happening. I don't think even someone from the Department of State would be able to clearly explain this because various moving parts. One thing that a lot of visa processing which happens outside the US at the consulates have slowed down because of their own logistic issues, and there is a huge backlog since 2020 when the whole thing was shut down. Then there's a huge backlog, and which they are catching up on that. And of course, every year you see a lot of visa applications being filed, and the numbers used, unused, and it's very difficult to get the clarity on the inventory. With all that in the background, December 14 is something very difficult to predict at this point. But I personally anticipate, that's just my wish or my guess, that probably sometime around next year, you might see some movement. Again, December 2014, December 2013, we don't know. But there might be some forward movement at least next year around this time, or even a little later, is what I think, if there is something like that.
So just for my knowledge, what is the current date now? What is the date of the applications that are currently being processed?
Yeah, to be accurate, let me double check on that. So I think what we have for the employment-based visa, the final action for employment with visas for December for EB2 for India is October 2011.
Oh, so he's got 3 more years by the time his 2014 gets picked up.
And as I mentioned, there are 2 charts, right? One chart allows you to gather your documents, be ready, assuming that the final action date becomes current, right? So that is May 1st of 2012.
Okay. This is for EB2. What about EB1? Is that faster?
EB1 always it's faster, but again at this time it's February 2022, 1st February 2022.
Wow. Okay. And he has the next question. Another question is related to birth certificates. Is it okay to provide birth certificate with minor name changes, or can we file affidavit if birth certificate is missing during I-485?
Right. So minor typos based on my experience so far. Again, I don't specifically quote any guidelines or policies from USCIS, but just based on my experience, if I have to share, minor typos or spelling variations should be all right. I have not seen USCIS particularly questioning those, especially if you have other evidences to provide along with the birth certificate that this is the correct date of birth. So again, it depends on what is the variation. If it is a missing I, missing H, then I think that's something that
So
is
what
okay.
options can he have? Just file affidavit, or how do
you can always get affidavits along with it? Again, you cannot get a non-availability because you have a birth certificate, right? So that's not an option. Then
can
probably
they do a name change in USA and then get a proper certificate?
possible, but again, the name change would have an impact on their passport, on their social security number, on their history here in the US, including the visa they might have got, right? So we are not really sure what is the deviation, what is the
So
type.
best is to stick with whatever is on that birth certificate.
Right, whatever you have, as long as they claim that it's minor, then maybe it's minor deviation. Sometimes I have seen that. So Deepthi is DEEPTHI, right?
So many, yeah.
Possible. So then that can be explained, and especially if they have documentation, their education documents, their previous government records and records here, that can be approved.
Okay, so just FYI to the audience, we will read all those other questions that you're posting online. We have not forgotten. We're just going in the order in which we received the questions. So please bear with us. This question is from a senior citizen. I'm not sure if it's applicable for this webinar, but I'm going to read. What is the procedure for, okay, he said bye, but a person is a US citizen, and what is the procedure to get OCI if Indian passport is not available?
Right. That's more to do with the Indian consulate. We don't follow that much. I personally don't have much knowledge on that. But I think that's something to pursue with the Indian consulate.
Indian consulate. Yeah, so they maybe just get a visa and go to India and come
I
back.
think there's a lot of information available online. Maybe if they go to the particular website of the Indian Embassy, you should be able to get information. And maybe from us, from Chicago Andhra Association, we can actually post the link if you can find out.
Which link are we talking about?
The link for the procedure for the OCI and other things, right?
Okay, sure, we can do that.
Yeah, there's a lot of information.
So the next question, like couple point, first 3 lines I drafted when somebody told me, and then they sent a huge text on what the question is. So please bear with me. If my L1 is expiring and my company has not filed a green card, can I apply for H4 EAD under my wife? So that is primarily that's the question that I understood, but the person wrote all the details. Currently, I am in L1 visa and will be completing 6 years of stay in USA by the end of July 2023 and reaching L1 max out period of 7 years by July 2024. So my question is, can I switch from L1A to H1B if I get new H1 through lottery for the current year 2023? And what will be the total valid period for the new H1B petition? That's the first question. Alternately, my spouse has L2 visa, like she came because of him. My spouse has L2 visa and entered into US on 2/4/2022 with L2 status. After that, she got a new H1 visa in 2022 through lottery, and visa status has been changed to L2S, from L2S to H1B valid from October 22 to October 2025. Now we're planning for permanent status in April 2023. And the question is, once she gets this H1 I-40, can I, which is the primary person on L1, convert my visa status from L1A to H4 EAD and continue the job with the same employer? If yes, what is the process for changing the status? Will it impact my current job, L1A, when converting COS from L1A to H4 EAD through spouse, employer / external attorney.
Right. So,
Mouthful.
right. Straightforward. The thing is, H4 EAD is not a status. H4 EAD is a benefit. So for someone to get the benefit of H4 EAD, they need to make sure that they are in a H4 status, right? So obviously, if he's on L1 and he's getting maxed out on the L1 status, then the only option that he has is to convert his L1 status to H4. Then fortunately, USCIS now allows to file for the wife's H1 if she is due for the extension, assuming, or maybe if there is a change of circumstances in the employment, if there is a material change, she can always file for an amendment on her H1 in a premium process. Then he can always include the change of status, which is H4 application and H4 EAD together, and file for that application so that he can immediately get onto the H4 status and H4 EAD, because the new policy says as long as the primary H1 is filed in the premium process, they will consider the H4 and H4 EAD applications also, along with the premium processing application. So they get this benefit of premium, and he can change his status from L1 to H4 and parallelly also seek H4 EAD. Then we don't know the timing. The thing is, this is sometimes becomes tricky if it is not approved all at the time, because there might be a gap of say a week, 10 days between the H1 approval and the H4 approval and the H4 EAD approval. So based on how these approvals come, then his job would be impacted. But at least there is a possibility, there is a hope that you can always file for the change of status from L1 to H4 and also file for the H4 EAD parallelly. And as long as your spouse is filing in premium, you get that option of getting that approved in premium, and you might be well placed without major interruptions in L1. We cannot say that there won't be any interruption. There might be, because assuming that H4 gets approved today, then he cannot be working from tomorrow. Then the H4 EAD might take a while before he realizes that, okay, he has a work permit, right? So those are the situations, but otherwise it's possible that he can change his status from L1 to H4 and also file for H4 EAD parallel, as long as wife is due for premium processing.
So you're saying there may be a gap by the time he gets this H4 and gets that H4 EAD.
Possible.
And when he is on L1, can he also simultaneously apply for H4?
Yes, that is only the way that he can get the H4 EAD. So when he's on L1, he can always apply for the change of status to H4. And until the H4 is approved, he can continue on the L1. There's no problem.
Once it's approved, then again, wait
he should stop working. He should stop working and wait for the H4 EAD. And now the new policy from the USCIS says if the H4 and H4 EAD is filed together along with the H1, and the H1 is filed in a premium, there is a good chance that all three would be approved at the same time.
Okay.
But you cannot guarantee that. It might sometimes not get approved at the same time. So as long as it gets approved at the same time, then there is a good chance that he can switch from L1 to H4 and also get the H4 EAD. But the question should be that whether he is eligible to get the H4 change of status. H4 is the status. H4 EAD is not the status. So he needs to get on to H4 to get the H4 EAD first.
Okay.
Hopefully
the person is listening live, and I know I'm getting some texts simultaneously, but I'll get to those after I finish my questions. From the date of, this is the next question. From the date of getting green card to the date eligible to apply for citizenship. Again, in the top, somebody asked a question about 4.5 or 5 years for green card to citizenship, right? So the same person has more questions on that. He's asking, from the date of getting green card to the date eligible to apply for citizenship, what is the minimum time gap or required stay in USA, and any international travel days, are they subtracted in calculating if required stay is met? Like, for example, if you have to stay for 5 years, if you spend 3 months in India, will they minus that out? That's what it's asking. Also, once a green card holder gets a citizenship, when or after how long a green card can be applied for a parent?
Right. Once they become a citizen, then immediately they can apply. There is no waiting time. Then the eligibility for the green card itself is tricky, and especially with the COVID situation, if people have traveled outside the country for longer periods, then we need to calculate. But the requirement is at least they should be fulfilling to stay here in the US for 180 days in a calendar year. There cannot be staying outside the US for more than 180 days.
Okay, so they don't minus out just because they're here, they went to India for 1 month or 2 months. They don't mind that out.
As long as you are staying here in the US at least physically for 180 days in a calendar year and you fulfill the requirement, then you should be all right. And again, I think we missed answering one question that the L1 person was asking, that can he also file for the H1B and how the period will be calculated, because he spent 7 years on L1 already, right?
Yeah.
So
Yes.
to answer that, again, he is not eligible for H1 because L and H1 together should not be more than 6 years.
Oh.
But he already maxed out on L1, so he's not eligible for H1.
Okay. So with this question on this green card, I think I understand the situation the person is facing. Maybe his mind is going only for green card, and maybe as a lawyer, if there are other options, you can say. This is a situation where one of the parent passed away and the other parent is not dynamic, like she's not, doesn't know, she always had support from husband or whoever, and now it's hard to live all alone when the son is here. So the person is trying to see how to bring the mother here on a visitor's visa he's bringing, but then that's only for 6 months. So I think he's just trying to support the parent. One option is that green card. Does he have any other option to support the parent?
There is no other option other than just sponsoring for the green card. Maybe if she has a visitor's visa, then she can always keep visiting at least for 6 months and then going back, right? That's an option.
So it's just 6 months, go back and then come back 6 months and things like that. Okay.
Until he gets his citizenship and he becomes eligible to sponsor green card.
Okay. So then the next question, we briefly touched on this before we started this webinar, because the question was confusing for me, but the lawyer understood the question. So I'm going to read this. Employee X on H1 with employer A and received green card EAD for future employer B. If suppose employee X on the dependent child used GC EAD for work, does that mean X employee can be considered as EAD to be used? And then the second question is employee X on H1 with employer A and received green card EAD by using future employer B, but employer X has not joined the future employer B. After 180 days, employer X can work for another company, another employer C by using GC EAD. So basically he's saying he wants to leverage the green card from some employer that he's not going to join or never joined, and is asking for options. Did you understand the question, Praveenji?
Right. To answer the first question, I think what he was asking, he or she was asking, that if the child started using the EAD, would that automatically put him onto that I-485 status and using the EAD? Is that right?
Employer X on H1 with employer A and received GC EAD for future employer B. If suppose employer X of dependent child used GC EAD for work, does that mean X employee also be considered as EAD to be used? I think
Right.
that's how you understood. Yeah.
Right. Yeah. No, because it's individual. Again, if you are on a H1B, you can continue to be on a H1B while your family, whoever got the EAD, it could be your spouse, it could be your child, they can always use the EAD. That should not be a problem. Then that doesn't mean that you are using EAD. You have a valid H1B, you can continue to be on a valid H1B. So that's not an issue. The other way around, if you start using EAD, then obviously your family cannot be on a H4. So if you don't have a H1, then they are not on H4. So it does not actually work from their end, but it works from your end. So if they are using their EAD, they are free to use because they have an I-485 application pending. And that's a benefit that they get to use the EAD, and they can, as long as there are no other complications. But it does not impact you, to answer your question number one. Question number two, then to start with, you never worked for this employer who sponsored your I-140 and now you filed for the 485 for a future employment. You are currently working with employer A, then maybe you have a different status on a H1B or whatever, then now since it's more than 180 days that since the I-485 is pending, you want to move to employer B. So for me, if I really understand the way that you presented, it doesn't really matter. Even today, you are not working with employer who sponsored your I-140 and 485. Then you are now trying to move to a different employer, and you are quoting 180 days rule only because to just see if there is an AC21 portability, right? That actually triggers only if you are working with an employer who sponsored your I-140 and 485. Since you never worked for them, it should not really matter. But you are into a situation where the question is whether you truly have a bona fide employment or not. So unless you have a bona fide employment, your I-485 application cannot be or will not be approved. So one of the evidences that USCIS might be looking is the period of work that you truly worked with this employer, right? Otherwise, if you don't have an intention to work for this employer, then your green card application is in jeopardy. Never do that. My advice would be to go and work for that employer who sponsored your I-140 and 485. And if at all, the whole purpose of this is at the end to get your green card, then don't lose it. Don't actually leverage anything, because there is no change of situation just because you are 180 days and the I-485 is pending for 180 days. You are not even working today, then with this employer, then you moving to another employer has no advantage. That actually becomes an advantage only if you have worked for that employer at least for a certain time. Then I think advice would be to go and work for that employer who sponsored, because that's bona fide employment, assuming that they have sponsored. Otherwise, your green card application is in jeopardy.
Thank you, Praveen ji. So just for the audience, I now went on to that Google sheet that I posted on Facebook, where you can go ahead and post more questions. And I see a couple questions there. If people have more questions, please post on the Google sheet that I posted on Facebook so that I can get the questions live here. The next question is, what are the hopes for dates becoming current 2023 for PD? I don't know what PD is. 05-2014 EB2/EB3. What is PD?
Priority date.
Okay.
Priority date is the date that which becomes current for them to file the green card. I think we already discussed that. We discussed 2014. When is that going to be current? Difficult to predict. Nobody can.
I have a second question or something. Okay. So the next question is, again, I am on H1. I have approved I-140. I am still far away from my green card. My son is 17 years old. Next year, he will go to college. My H1 extension due in next 6 months. Should we change him to F1 visa, or still he has some time?
Right. So there is no disadvantage. Let me put it this way. There is no disadvantage for him to be on F1 unless it impacts anything else for the school. Sometimes if a person is on a student status, if an F1 international student, then the fees might be different, right? They will not apply the in-state. There are some universities which apply in-state if the student is on a H4. So you need to see if that has any impact. But otherwise, for the immigration, I always prefer them to actually have the F1 application as soon as possible. There are two advantages. Number one, it is taking more than 1 year sometimes to get the change of status from H4 to F1. Then the second thing is they would be eligible to work in the school if they are on F1. If you are on a H4, they are not eligible to work. Right? Sometimes you might find an opportunity in the school to work at least for 20 hours in a week. It's possible. So that is possible if you are on an F1. So these are the two advantages that I see. And he being on a F1 is not a problem for you, is not a hurdle if your priority date becomes current, and you can always include him in your 485 application. Just because he moved from H4 to F1 does not really impact in any way. But the only impact, the downside that I see sometimes, that since he's on F1 student status, then out-of-state fees or international student fees might apply. And it is university to university, there is no specific rule. Then some universities do, some states don't. and especially if they have completed their high school education here. There are some universities who are applying in-state student fees, even if they are on H1 student status or H4. So you need to just validate and check all the information which I'm not aware. But there is always an advantage in terms of immigration because you're starting this process early, then you don't have to panic in the last minute. So if he's 17 years, then it might take 1 more year, 1.5 year to get their fund status approved. Then on top of it, they are eligible to work or do any kind of internships uh, in summer if they're eligible on F1. So these are the advantages.
Dependent status is lost at 18 or 21?
21.
So if he's only 17, college also he can finish as a dependent, right? Without F1?
Possible. But as I said, the advantage is, yeah, you're right. He can even just complete his college by that time. But again, if they are pursuing any other courses where it takes more time, then obviously at some point they have to get on to F1.
F1.
Then,
And is F1 easy, or is it also like this H1 where there's so much struggle to get a visa and all that?
Processing time is delayed. Again, it's tricky application because for an F1 you need to prove that he has strong ties to his home country. He or she has to prove that they have strong ties. Then the family has moved here. Then how would you prove that you still have strong ties? And especially if they have completed all their education here in the US, from elementary, middle, and high school, and now they are going to the college. Then it's a different standard to prove that they have strong ties to India. Then all the parents are here. Then the siblings are here, probably they are born, right? So it's a difficult application again to prove, but possibly.
So that the child protection law that you talked about during green card, that is for green card, I understand. But can anything be done for people? Again, this is the same situation. The child is legally came to this country. It's just because of the time process, it's just getting delayed, and the child grew up here. Now, if they have a green card, I know that new law that you said about child protection is going to help the child. But in this case, where the parent's green card itself is delayed, but the child has grown here for so long, is there anything that can be done for them?
Haven't got the Congress or the administration have not gone that far to address this issue. And honestly, this is an issue that we always discuss, even within the firm. That personally, I think they should be eligible to file for the 485 because, as I was mentioning, there are two charts in the visa bulletin, right? One is a date of the filing date, which that what that means is that date allows you in anticipating that your green card might become a final action date in the future time. So you start gathering your documentation. So then if that is the case, then as well allow these people to file for their I-485 immediately when the I-140 is approved. And there are some proposals pending that way. That once the I-140 is approved, wait for 2 or 3 years, then automatically you should be eligible to file for the 485. If they're actually filing for the 485 and the visa numbers are available, then that's when the dates gets frozen. So we haven't got that far in the discussion to find a solution for this problem yet. So at some point,
if somebody comes to you for an advice in this situation, what would you say? Just go back to India, or I know it's cruel.
Apply for the F1, continue your education here and wait and see. And of course, it's a regular path again to go back to the H1 and go through the employment-based visa. And at some point, these things might change. And especially for people who have got education here in the US, there might be a new law which allows them to get their green cards faster. That's the anticipation. That's what we are all to fight for.
Hoping for. Okay. Yeah. All right. So then I'm going to move. This question is again similar. These questions now I got in some texts where people forwarded some questions. When can we expect EB2 2014 to be current? We just talked about it. What happens if GC holder lands past 6 months outside country? Okay, basically saying if the person stayed outside the country for more than 6 months and is a green card holder, what happens?
Right. So to read through the guidelines strictly, then their calculation for the 5 years eligibility to file citizenship, the clock resets when somebody stays outside the country for 180 days.
Oh,
because
they stayed for 4 years and then went to India for 6 months. You have to again wait for another Oh
5 years, right? So that's yeah, that's because USCIS assumes or presumes that they don't have an intention to reside in the US.
Okay. So that's the only harm. Like it's just that for becoming a citizen, you don't lose your green card if you stay outside.
Yeah, they allow you to stay up at least up to a year. Prior to a year, you can always come back if you have a valid reason. See, there are two criteria for you to determine to keep your green card. One is the criteria that how long have you been staying outside the country. Then if it is less than a year, you are still allowed to come back. But if you keep doing this, then at the port of entry, the question is whether truly you have an intention to reside in the US, because it looks like you are visiting the US and staying outside else, right? See, assuming a person is actually traveling, say for 15 days or a month in every year to keep his green card, then obviously that is allowed. Maybe they will allow him to enter. But once he repeats, he or she repeats this scenario, then at some point there would be a question at the port of entry. In the last 3 years, you've been staying outside the country for more than 2.5 years, and you stayed only here for 3 months or 4 months. So that proves that you don't have an intention to reside in the US, then they might strip your green card at that point. Unless you have a valid reason to explain and you have really strong ties and you have never abandoned your status, your permanent resident status in the US, then that becomes difficult. So always try to maintain your residency by truly living in the country and having all the documentation and evidences in place.
So the next question is OPT EAD and STEM EAD completed, that is 28 months period. Can we register for new masters? And after completion, will they get another OPT EAD?
Right. The OPT is given only at the program level. So they have to go to the PhD level to get another OPT. So once
So if they have masters and have OPT and they finished it, then you have to go to the next level of study.
Right. They will never get an OPT again for that level of study.
Okay. So so I think I already read this question. What happens if a green card holder lands in USA past 6 months? How much is the risk? You just explained that. And the next question is, can a religious worker visa person shift to H1? Can they apply while in US, or do they have to go back to the country of origin?
Can you repeat the question, sorry?
Can a religious worker visa person shift to H1, like a priest or somebody? Can they, whatever visa they get, can they switch to H1? Can they apply while in US, or do they have to go back to the country of origin?
Change of status is allowed even from R1 to H1. They can always file for a H1B lottery, and if they are selected, if they are eligible, and they can always move to H1. They don't have to go outside the country just for that specific reason. But if they have any gaps in their visa status or something, then that would actually trigger. They would not get the I-94, then they'll go outside the country. But change of status from R1 to H1 is possible while staying in the country.
Okay, so these are the questions that I had so far. I'm going to go into the Google Sheet to see if anybody else posted more questions, and I'm going to check in Facebook one last time. If we are good, then okay, that was Google Sheet. That was the last question I already read, and I'm checking quickly in Facebook Live. For some reason, I see on 07. Last question I already read. Sorry, and I'm checking. I need to go back on this. For some reason, I see on 07. Last question I already read. Sorry, and I'm checking. I need to go back on this. For some reason, I see on 07. Last question I already read. Okay, so all right. So questions from Facebook. My mom has an important wedding to attend and might be past 6 months that me away from. Basically, she has something to attend, and it may be past 6 months before she's in US. By the time she returns to USA, okay, my mom has important wedding to attend, and it may be past 6 months by the time she returns to USA. So question 2, what can be done with regards to children whose parents are still on H1? They seem to be having several restrictions, including risk of being deported back due to out of status situation. What is the advice for such children? We
First
just
question.
one person. Yeah, first one is parent is on a green card.
The risk is the parent might not be eligible to file for citizenship if they stay outside the US for more than 180 days. Then coming back is okay as long as they're coming back within a year with a valid reason, as long as they never had an intention to abandon the permanent resident status here in the US. So that should be understood and planned well. And the second question is vague. I cannot understand what they really mean.
Second question is, what can be done with regards to children whose parents are still on H1? I think there was one person who asked about the F1 for the 17-year-old child. It's a similar question. They seem to be having several restrictions, including risk of being deported back due to out-of-status situations. What is the advice to such children? Basically, F1 and all that you mentioned, right?
If they're out of status, and obviously there is always a risk of deportation. There is nothing that you can do. Then always you should just make sure that you maintain the status. And usually the deportation or the ineligibility to file for the adjustment of status happens if they are unauthorized for more than 180 days. So you got to be careful on that part. Like never lose your status. Maintain your status by continuing your education, filing for the F1 or continuing your education and then going back to H1. And there's several options like any other person, right? So you need to pursue those. Then that's only the way.
Okay, and then there's a last question. We kind of answered this, but this is coming from a different person. I have a question regarding birth certificate. If the name is misspelled in the birth certificate, do we need to get an affidavit, as it's difficult to get it corrected in India? We already kind of talked about it. So
yes, get affidavits, then get any other documentation proving the name as it is. And based on my experience, the minor differences in the name should not be difficult, and USCIS is not has not questioned in the past that I have seen so far.
So with this, we would like to, on behalf of Chicago Andhra Association founders, chairman, president, and board of directors, I would like to thank Praveen Medikundam, the lawyer with us today, for spending so much time. If you actually go to a lawyer's office for 2 hours, that's a big chunk of money. So thank you for spending some time with us. For the benefit of the audience, he's here in Chicago and he's licensed to practice throughout the country, all 50 states. He can be reached at 847-995-1515. His name is Praveen, and his website is www.bizlegalservices.com, bizlegalservices.com. Please avail his expertise and to get you can schedule appointments and stuff like that. And as we read at the beginning and in the middle of this seminar, participating in this webinar does not constitute for attorney-client relationship. Using attorney Praveen or his firm services requires application of professional expertise and judgment on a case-by-case basis, for which you should schedule a consultation and seek advice and services as required. This webinar is an effort to bring notice of general immigration law related options and not a legal advice to any particular individual. So with that, do you have any closing, based on the questions that we got, lawyer, do you have any questions, any closing statement that you want to tell our viewers?
Right. Few general things I wanted to share based on the experience dealing with the clients all the time. See, one thing that you all have to understand, we all have to understand that there is no right way. There is no right way of doing any wrong thing. So always try to take an advice from any attorney or anyone who is an expert in the field, and try to plan your immigration status accordingly. And that should be our way to go. The thing is, it's very important. Immigration laws are very complex, especially based on the current situations and the time that it's been taking to process the application. It becomes more complicated. So always try to take an advice from any attorney and try to plan your immigration. And always remember, there is no right way of doing any wrong thing. So never do anything wrong. Always take the right advice, be on the right side of the law, and that should protect all of us.
So we would like to thank you, Praveen ji, for giving your time for Chicago Andhra Association. Thank you so much for your support. And President ji, if you are on the line, you want to say a few words?
Yeah, Praveen Garu, this is Gauri. I think I just really want to take this
Gauri Shankar ji, are you
opportunity.
online?
Are you able to hear me?
Okay.
Yeah.
If not, thank you so much for
Praveen
your
Garu,
time.
I just want to
Thank
take
you.
this opportunity to
Thank you to all the audience, and hopefully you benefited from this seminar from Civic Engagements.
Yeah, Praveen Garu, I just want to take this opportunity to thank you. And yeah, I for the benefit of the viewers, it's
from Civic Engagements.
Praveen Garu can be reached at his office and get his legal advice to get your issues resolved. Yeah, I for the benefit of the viewers, it's Praveen Garu can be reached at his office and get his legal advice to get your issues resolved.
Thank you, sir. Thank you, and wish you all good luck.
Yeah, I would like to thank all the viewers who participated and asked questions in advance. That helped us prepare rather than suddenly throwing questions at us. So thank you for using the Google form. Going forward, Civic Engagements will have more webinars on relevant topics. Yeah, please avail the Google forms that we send out from time to time so that we're prepared and have a productive session. Thank you once again, Praveen ji.
Thank you. Thank you all. Bye-bye.
Thank you.